Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Today, team, we're going to have a think about when we can proceed, when we can sue a company that's in liquidation, in the process of being wound up. Some interesting facts. All right, we've got Mr. A. Mr. A owns a car. Mr. A causes possession of the car to go to a company for the purpose of that company renting out the car. And apparently it's a pretty whiz-bang car and it's fast and it has a brand name that I've now forgotten. But in any case, Mr. A causes possession of the car to go over to our company for the purpose of renting it out. Right. While the car is in possession of our company, what happens is a detailer associated with the company, Ferris Bueller style, hops in the apparently very fast, very exciting car, and in the process of driving it, causes it to be written off. So the car's done. Now, relevant for our discussion today is that what Mr. A says is, I would not have given possession of my wonderful car to this company if this person here, a different natural person, so not our car detailer, but another natural person, hadn't represented that the company had the right insurance. That makes sense? Mr. A is saying, I gave the company possession of the car. The reason I did was because our friend here represented to me that the insurance would be fine, and then our car detailer went off and crashed it. Right? So we head to the district court. Mr. A sues and he gets up. He gets up, and the nature of that victory is that he gets what's called a several judgment. So it's not joint, but liability is several between some of these other parties here. What he's suing for is the amount of damage done to his very expensive car. And in essence, what is found, among other things, is that our company is liable to pay some amount, let's just call it 120,000-ish for the sake of our discussion, and our representor, the person who Mr. A says led me to form a belief about the insurance, is liable for some other amount. Let's call that 160,000. Make sense? In the district court, what the district court says is two different types of liability, 120, let's say, for the company, 160, let's say, for the natural person. Right. What I now need to tell you is that the company is in the process of liquidation, and that what the liquidator has said is that he is unfunded in the liquidation. He's got no money to spend, and so he's not in a position to resist any appeal. And so we now come to the thrust of today. It's discussing the appeal. Now, having reviewed the law and pursuant to a decision that came down in about 2012, Section 471 capital B of the Corporations Act is going to be relevant for an appeal. Why are we talking about Section 471 capital B? That's the section of the Corps Act that says you cannot commence proceedings against a company in the process of being wound up without the leave of the court. So, what's that 2012 decision I'm referring to? That's a decision where the court had to come to grips with, well, is appealing an earlier decision, is that commencing proceedings? Is that something that Section 471B would prevent? Or is that what might be thought of as a continuation of the first instance decision? And in short, for your information, the filing of a summons seeking leave to appeal in the Court of Appeal is a fresh set of proceedings. So, pursuant to 471B, you need to ask the court if the court's okay with you going ahead against a company in the process of being wound up if you want to appeal against an early judgment. I know it's really fiddly, but let's just wind back to our factual matrix. Remember, we've got our bloke suing our company for the car being written off, and is also suing the person who made the representation before the car was written off, right? So we've got the judgment for 120, 160, and Mr. A is appealing. Mr. A is appealing to say this several judgment that is one part for one party and a different part for another party was, in short, incorrectly found, and it should have been a joint and several judgment. Does that make sense? So that either or both parties could be pursued for the entire amount or some portion of it. Why does Mr. A care whether it's joint or several? Well, because the company's got no money, and so the award Mr. A has against the company means nothing. And so Mr. A would love to go chase our natural person who presumably has some money in respect of that judgment. And our natural person here is also appealing, or also is seeking section 471 capital B leave to appeal, because essentially he wants to be removed out from the argument. He said, look, my representation has nothing to do with me. It relates to the relationship between Mr. A and the company. So Mr. A is appealing to say, I want a joint judgment so I can chase everyone for the money. And our natural person, our representor over here, is appealing to say, well, I don't want any part of this at all. So the court is forced to consider whether section 471B, which says you can't commence proceedings against a company that is in the process of being wound up unless the court says it's okay. What the court does is work through the nature of this dispute, is to work through the car crash and the representation and the relationship with the company and the insurance and all this sort of stuff, or the lack of insurance, and say there are complex legal and factual issues here, and based on the quantum of the claim, based on the nature of the proof of debt process, which is one of the ways you can engage with a liquidator, in short, this is an appropriate decision where leave pursuant to section 471B should be granted. And so it was. And so the short take-home nugget of truth from that is, if you are looking to pursue a liquidator and looking to appeal, you need fresh leave to do that. Today, the parties, both our representor party, a natural person, and Mr. A, our car owner, were granted leave to do that, leave to appeal pursuant to section 471 cap B, and so off they went. But one can imagine the disappointment after the parties weren't granted that leave. So something to bear in mind, and hopefully a little bit of value for you. And I will look forward to catching up with you again soon for another coffee, hopefully a little bit closer to me that time, and another case note. Have a great day. Cheers.